G'day. Welcome to the AgriCoach podcast for families on the land who want to grow their family's wealth and prosperity across the generations. I'm your host, Ben Law, and I'm the financial bloke. Welcome back to the AgriCoach Wealth and Wisdom podcast. Today, we're going to nerd up and get all technical, legally technical. And to help me with all this legal nerdery, back for another episode is my mate, Tim Rivett, a lawyer and serial podcast guest. So why are we going all legally nerdy? Well, following are a number of questions that I get asked often when it comes to estate planning. Number one, what is a testamentary trust? 2, do I need one? 3, I think I've got a testamentary trust, but I'm not sure. Isn't it just like an enduring power of attorney? So today we're going to tackle all things testamentary trusts, which, if you've got an agribusiness, especially an intergenerational agribusiness, you should consider their use carefully with your lawyer when crafting your estate plan. And for those who don't know what I mean by estate planning is simply the legal documents you put in place for when you die or lose capacity. And one of those examples is a will. Before we start, we need to do the obligatory keep those pesky lawyers away disclaimer. So here we go. The information contained in this podcast is general in nature and for education purposes only. It's not financial advice. It's not tax advice. It's not legal advice. You should not act on the information without appropriate specific advice for your particular circumstances. I'm a former financial advisor, but choose to no longer be licensed and cannot and will not give you specific, personal, legal, or accounting advice on this podcast. So now that we've got the lawyers happy, or well, kind of happy, welcome back, Tim.
Thanks, Ben. Always exciting to be here.
It is. Great to have you back. It's been a while now. I was just trying to think. It'd have to be sort of 9 months, I think, since you were last on, wasn't it?
Yeah, we've both been busy doing other things as ideas percolating, but I'm really excited about this one because this is my nerd nirvana, as I call it. I'm really excited about the trust one.
It's interesting, mate. A big shout out to Auctions Plus. Jackson at Auctions Plus gave me a bit of feedback the other day because they actually share the podcast to all their subscribers every fortnight, which we really appreciate, sharing the wealth and wisdom. And he was saying that some of the podcasts that get the biggest traction when they share it out there is actually the technical ones. And I was really surprised about that because I like learning the technical stuff. I just didn't realize how many farmers and graziers actually want to understand the technical side of some of these things. And I think it's really important to learn those technical things, not because you want to be a lawyer or you want to understand it completely, but it helps you understand if it's important and you should know about it and gives you enough information to be able to then go to your lawyer and have a reasonable conversation about it and understand what they're talking about.
Yeah, knowledge is power, Ben. You and I have always talked about technical things because we're both interested in it, but we always assumed that no one else was, except for maybe your mum and my mum would be the only four who ever listened to that technical podcast. So this is good. It's been a pleasant surprise that maybe people want to hear about this.
Estate planning, that's what we're talking about today, which just in really simple terms for everyone listening is the process and the analysis and then the legal documentation that you put in place for when you die. And things like wills is a great example of that. And what I thought about when I was looking at this, Tim, I was thinking, well, what's a question that comes up all the time from the families that I work with in the estate planning or the legal side? And one of those is the difference between what I've heard coined a simple will and a complex will. And essentially the difference I've always understood is that a simple will is simple. It's very, 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 very basic in its execution, but a more complicated will has what they call a testamentary trust in it. Now, we've done podcasts before on what is a trust, individually. So if you're running a business, what does a family trust look like? But a lot of people don't understand what a testamentary trust is or a testamentary discretionary trust. So let's kick off, Tim. What is a testamentary trust?
So, Ben, testamentary trust is a totally different type of thing to the more traditional family trust, which I think if people are in business or in rural enterprise and your accountant has created this trust thing for you, it's very likely to be a family trust or a family discretionary trust. they're designed to run businesses, hold assets while you're alive, that kind of thing. So we're not talking about them today. We're talking about the second type of trust, which we call testamentary trusts. Very simply, they are a trust that is created under your will. Okay. So how do you remember the difference? Because trusts get thrown around a lot at barbecues and advisor meetings and conferences, that type of thing. As a general rule, if your accountant created it for you, it's probably the first type, the family trust used to run your business or do something like that. If your lawyer created it for you and your will is 40 pages long instead of 4 pages long, there's a very good chance that you've got one of these testamentary trusts as part of your estate plan. Now, how do you remember it? Your will is called your last testament or your last wish. That's where the term testamentary trust comes from. But for simplicity, you can call it a will trust. I have heard them called lots of different things. There's the concept of a bloodline trust, which is another name for a testamentary trust, just something that keeps your assets within your bloodline. They're also called a protective trust. And my very favorite is the "my son-in-law is an idiot" trust.
Yes. So let's try and protect those assets. That's essentially what it's for, isn't it? Is to protect your assets once you've passed away. So to follow on from that, the difference between a basic will and a more advanced will is generally a testamentary trust. But what are the benefits or advantages of having a will that has a testamentary trust in it?
So your main one, Ben, is definitely asset protection. So, tongue in cheek, if your son-in-law really is an idiot or you want to protect your assets from anyone, including your own children, if they're spendthrifts or they have substance abuse problems or they're just not very good with money and you're leaving them some wealth, then definitely asset protection. We talk about the Forrest Gump events of life. If you know the movie, Forrest Gump's running along and there's 100 people behind him and this fella comes up and says, "Hey, I need an idea for a bumper sticker. What do you got?" And Forrest Gump steps in a big pile of doggy doo-doo and said, "Shit happens, stuff happens." That's life. Life gets in the way of your otherwise very good plans. So if people sue your adult children, then their inheritance is up for grabs. If your adult children get divorced, separated, then their inheritance is up for grabs. If you leave assets to young people, they may not make very good decisions with that. They might blow it and then their inheritance is gone. So the main advantage definitely of these testamentary trusts is asset protection, protecting wealth from third parties and from themselves. Okay, so that's number one. Now, the tax stuff.
This is where we get technical, isn't it? Jumping into the tax side.
This is the technical stuff. So the tax stuff, here's the simple version of why these testamentary trusts are so cool. You can protect assets, which is awesome. But what you can also do is you can be very tax effective about how income generated from your wealth is distributed amongst family members. So if you've got one of those first type of trusts we were talking about, the family trust that your accountant created for you, your accountant has probably told you that if you've got minor beneficiaries, children or grandchildren, I'm talking about kids under the age of 18, you can only distribute them $416 before the tax man says, "I'll take 55 cents in the dollar if you distribute to minor beneficiaries." Okay, so back in the good old days, we could do lots of cool things with those distributions to kids. Haven't been able to do it for 15 or 17 years, so the jig is up. Now, if you have a testamentary trust, it's a totally different kettle of fish. Every eligible beneficiary under one of these trusts can have marginal tax rates. So marginal tax rates is, give or take, each of us can earn about 20 grand before we start paying $1 of tax, right? Totally different to the $416 cap that we have under the other type of trust. So here's a really simple working example, Ben. I only do lawyer maths, so I need round numbers. You die, you tip $2 million into a trust, you invest that at a 5% return. Okay, so there's $100,000 coming every year in passive income. Maybe you bought Commonwealth Bank shares, BHP shares, maybe it's a term deposit, whatever. But you've got to do something with that $100,000 of income, which is created from that wealth, that asset. Now, if you've got 4 kids, then what you can do is you can distribute that income on paper to each of those 4 kids. So they all get 20 grand. And so your son, daughter, and 4 minor grandchildren all get 20 grand on paper tax-free every year for up to 80 years. That's how long the trust can operate for. So this really is I shouldn't even say a secret, but it's one of the reasons why the wealthy keep their wealth, because they've asset protected it and they're bringing up their children and grandchildren, tax-free to an extent. It's a really cool structure.
It's interesting, Tim. I had a family that I worked with probably 15 years ago as a financial advisor, and they had a very successful business in the agricultural space, and Dad passed away from cancer and left 3 kids. And those 3 kids, one of them had some mental disability, and essentially a TDT or a testamentary trust set up upon his death, and there were assets moved into there plus his life insurance. There was a couple of $1 million worth of life insurance. And when we looked at it from a tax point of view, essentially with the 3 kids and they could distribute, I think it was something like, back then it was like they could distribute $80,000 or $90,000 a year tax free to the family, and it essentially, the tax savings they made paid for the kids' education at that stage. So I saw that in real life, the benefit that people got from those tax savings. It was quite significant. So I just wanted to reinforce that.
Yeah, Ben, it's one of those things. Our mantra in our lines of work is, if it sounds too good to be true, it probably is. And this is one of the rare exceptions to that one of these testamentary trusts really does sound too good to be true. But remembering that the price of admission is death. So to have one of these, you have to pass away. So what you're really doing is you're creating a legacy for a number of generations after you, because if you create a will that sets up one of these trusts, it's not going to benefit you at all. Nothing changes, which is another reason why I love these structures. You sign a will, nothing changes. You've got no further paperwork, no further tax returns. It sits on a shelf until you meet your maker, and the trust only gets created upon your death. None of us are getting out of this alive, so why not be smart about what you leave behind, but also the way in which you leave it behind?
Yeah, it's interesting, Tim. The other thing, and correct me if I'm wrong here always, is you can't do this after the fact. So someone can't come in as your executor and say, hey, wow, Dad passed away. We'd like to set up a testamentary trust to be able to run this to protect our children or our grandchildren, the assets for those kids, protect them from themselves or their business or spouses. We'd like to set that up later on. It's either done before you die or it's not done at all. Is that correct?
Now, not correct, Ben. There is a little known tool in the toolbox called a post-death testamentary trust, where if we're quick and smart about it, we can actually swoop in and create a trust after somebody has died. Much more complicated, costs about 5 times what a testamentary trust in a will would cost, but we have done it multiple times, and you get to enjoy all the same benefits. You've just got to be quick about it.
Yep. Okay, perfect.
So one other thing I just want to mention, Ben, is this concept of children going and doing a gap year overseas and then never coming back, which we come across in our practice on a very regular basis. Now, what the kids tend to do is they convince mum and dad that they're just going for a year to pull beers in London or, ride the bull in Wall Street or whatever it is kids do nowadays. Fast forward 10 or 15 years, they've met a spouse over there and they're not coming home. Now, if you've got foreign beneficiary children, you definitely need one of these structures, because the taxman treats you very, very differently if one or a number of your beneficiaries are living overseas as at the date of your death. So that's a huge trigger for us, that there are smart ways to protect your estate from the taxman when it comes to foreign beneficiaries. Hugely advantageous to have one of these structures.
Now, Tim, I'm just going to try and put that into some practical terms if I can here. So let me give you an example. Let's say you're running a rural production business, high asset value, low cash flow for a lot of people. So let's say you've got a farm worth, I don't know, let's pick a number, $20 million. And you've got that farm, pass away, you leave it to your 2 children and think, okay, well, that asset gets transferred down. You've got one, say, living on farm, one living in London. And for some reason, the farm gets split 50-50 between them, just for this example. Would that then trigger a capital gains tax as if the asset had been sold if that beneficiary was living permanently in London?
Yeah, quite simply, Ben, it can. There are rules around the types of assets and the use of those assets. Some are exempt. The family home is exempt. Farms are a little more complicated because they represent both the family home as well as a business-making asset. So definitely a complicated area, but anything to do with shares, ASX-listed shares, foreign-listed shares, all those types of things have the consequence as if your estate has sold all of that property at market value. Taxman sticks his hand out and says, I'll have my capital gains tax. And you say, but I haven't sold anything and I don't have any cash to pay the tax. And really the only choice the kids have is to actually sell assets. And if your estate plan didn't contemplate the sale of the farm to pay the tax, that's a de facto death tax.
And that's a major problem, because if your farm's, you bought it for $1 million, 25 years ago, and it's now worth 20 million, for example, and you've got half that asset, or one farm maybe worth 10 going to that beneficiary overseas, it's triggered to as if being sold. There's a $9 million capital gain. Even if you discount it, that's still a massive amount of tax that's going to come off something like that if you get it wrong.
Yep, it'll make your eyes water. And, it's really sad when we see that type of thing occur because it's so preventable. A good estate plan will prevent that from happening.
We're talking about permanently here, Tim. So, your daughter's moved to London and met someone from London and lives over there. But what about if they're over there on a travelling holiday and they're working in London and they're going to stay 1 or 2 years or 3 years, and you happen to die in the middle unexpectedly early? Is that still going to have the same problem, even if they're not looking at permanently residing over there? Today's episode is brought to you by AgriCoach. You've worked bloody hard over the years and you've built a solid operation. But as your children grow up and start their own journeys, you're beginning to think about the next 5, 10, and even 15 years and how to keep driving the business forward and ensure a smooth and successful succession plan. Preparing the business, preparing the next generation, and preparing for your eventual retirement all requires a solid plan and a proven process. Unsure about the right steps to take? Head on over to agricoach.com.au/webinar to learn more about our Succession Proof Your Family webinar. AgriCoach, aligning families, growing wealth, and protecting legacies. And now, let's get back to the episode.
Yeah, look, if they're on a holiday overseas, it's not an issue. The tests around foreign beneficiaries, there's usually two limbs. One is, are they paying tax overseas, i.e. are they working and earning money overseas?
So they're working in London, they're earning money, paying tax?
Definitely, they're a foreign beneficiary. And especially if one of your children stayed overseas and either became a permanent resident or some sort of dual citizen, then they will definitely be caught as a foreign beneficiary. So like any area of the law, it can be nuanced. Don't be worried if your kids are in Europe for 6 weeks and they're coming home. But if they're currently overseas and there's whispers about when, it's enough to at least look at it.
Yeah. Okay. So realistically, the major advantages, just to go back and summarise those up, is asset protection, which obviously, as you mentioned, my son-in-law's really an idiot, or my daughter-in-law's really an idiot. We want to protect the next generation. We also want to look at the tax implications. How do we deal with that from both an earnings tax whilst I've passed away over time, but also any potential CGT on assets. But you'd have to make sure you get that structured well. And for me, it's like a preventative action. Doing your estate planning and working out whether you need it is probably well worth the money, because even if you try and do something after death, it's going to be far more expensive, which you alluded to. So that leads me to the next question. How do you identify if you actually need a testamentary trust?
Yeah, really good question, and one of the most common ones we get asked when people have either heard about these bloodline trusts or the my son-in-law's an idiot trust at a barbecue, and they come to us and say, should I get one? Do I need one? So here are the basic triggers of how we would guide people through it. Now, a word of warning, not everybody needs a testamentary trust as part of their estate plan. There are lawyers out there who like to write these for everyone. Just be careful with them because they're not necessary for everyone. But here's some examples of why I would recommend to a client that they could or would be necessary.
Yeah, could consider it.
Yeah, at least consider it. If you've worked hard, you've generated wealth, and it's the type of wealth that's worth protecting. Now, that means different things to different people. There's no magic number that we use to say, you've got too much money, you need a testamentary trust. The example I use for people is if your son or daughter get married and the relationship doesn't go the distance, and you lose a portion of your son or daughter's inheritance to that then ex-spouse, how would that sit with you and how would that make you feel? And the example I use is sort of between, let's say you have 2 children, they're inheriting 50% each, potentially half that inheritance is up for grabs depending on lots of family law factors, the length of the relationship, all that fun stuff. But let's say a quarter of your estate goes to your ex-daughter-in-law, son-in-law. How would that sit with you? And if you shake people upside down and say, this is your wealth and this is what that 25% might be worth, most of the time they look at you and go, no thanks, what can be done about it? Okay, so the trigger often is you've got enough that is worth protecting. Now, intergenerational and sentimental assets, rural properties, farms that you inherited or acquired from family members, properties where your family cemetery is, those types of sentimentality reasons are obvious. If the farm means a lot to you, then it's worth protecting, right? Remember our Forrest Gump events of life. None of us really know what's coming down the road. So if you've got an opportunity to protect it, then why wouldn't you?
We also have to accept the fact that the divorce rate is significantly higher than it ever has been in the past. So it's a very real possibility for most families these days.
It's worryingly high. It's in the 50% range, Ben. So, for young people getting into either de facto or marriage relationships now, statistically half of them will not go the distance. And that's extremely alarming in the estate planning sphere, because family law is a hugely powerful jurisdiction. It can reach through lots and lots of different structures like family trusts. If you think your assets are protected because they're in a family trust, think again. If they're in a testamentary trust, they're very difficult to attack if the structure is created correctly. So family law risk, blended families, stepkids, if one of your children gets into a relationship and there are children from a previous relationship, that's, a potential headache along those lines. And definitely kids with special needs, Ben. So if you've got children, as I alluded to, who are spendthrifts, there's some gambling stuff, there's substance abuse, they're just not very good with money, these structures can be great asset protection mechanisms so that if they're inclined to squander it, they can only squander a very small part of it, and the capital that you leave behind is going to be protected from themselves. What
about people with high-risk professions, mate? So the next generation coming through, they're in higher-risk professions. They're not just farmers and graziers.
Yeah, this comes up a lot. We deal with lots of rural families whose children have gone to university and entered into one of the professions, so doctors, lawyers, accountants, any sort of business in a services realm. If you leave assets to your professional, i.e. doctor, lawyer, accountant, child, and they get sued for professional negligence, which unfortunately is common and is becoming more common. We're becoming a bit more like America, where if some accident happens, we're looking for someone to blame, and the blood-sucking lawyers circle. Then yes, if you leave assets to those kids and they become their individual property, then everything's up for grabs. So you can stick it in one of these testamentary trusts. It's for their benefit. They still get to enjoy the wealth that you've left behind. But if they end up in the sin bin, i.e. bankrupt or in real trouble, those assets are protected.
What about second marriages? So what I'm getting at there, Tim, is that if there's a big age gap between spouses and then all of a sudden you say, okay, well, if I pass away, it hands down and then my spouse remarries and then they have children, because I think that's a real fear for a lot of families, is then stepchildren come into the scenario and then all of a sudden they're eligible just as much as anyone else for an estate challenge.
Yeah, look, here's a very simple classic example is that the farm is owned by a fella. He gets into a relationship and marries a younger lady. There's an assumption that he's going to pass away first. He has to sit there and think, well, if I give my beloved wife the farm, what happens to the children I had from a previous relationship? Or what happens to the children that we had in that relationship if my much younger partner remarries or repartners after I'm no longer here? So again, very complicated. There are tools in the toolbox to cover that. If you put assets in a testamentary trust, it means that while people are alive, they can enjoy the benefit and the income and the wealth that gets generated from them, but they can't decide to go and squander it, and they tend not to lose it to those family law relationships.
It's interesting, Tim. Just to give it a bit of a side example, is one that I saw was a catastrophic problem. Was I had a family where they had multiple blocks, and mum had passed away, dad had moved into town and retired, and the next generation had taken over all but a quarter of the farms. So a quarter of the farms were still in dad's name. And then the way it had been structured was, and this is not an estate, well, sorry, it is an estate planning problem, but it was identified before then. And so a quarter of the farms were in dad's name off farm, and he was in his, I think, 70s or 80s, and he remarried someone. And then all of a sudden we looked at the scenario and said, well, if dad passed away, his new wife and then her spendthrift, drug-addicted children would then potentially be able to challenge a will and get access to that quarter of the farming operation. Now, that quarter of the farming operation is if it got lost or a substantial chunk of that got lost, the farming business was no longer viable. You take that equity out of the business, and we did the decision tree if this happens, and essentially the whole farming business, fifth generation, would have to be sold, because they couldn't carry the level of debt. And so that was an estate planning thing we managed to catch early. We did some succession, transitioned assets, etc. But still, these are the sorts of things that we need to think through about how not only testamentary trust, but also estate planning can be a really important part of the process. Yeah,
and the decision around do I need a testamentary trust is very often combined with a broader estate or succession planning exercise. So, we don't look at testamentary trust in isolation. We look at the whole scenario, and we look at all the tools we've got in the toolbox. One of the most common ones we have is the testamentary trust. But there are lots of other cool things we can do. Gifting assets, gift and loan back assets. There's all sorts of things we can implement to suit that family dynamic and suit the asset dynamic too.
Yeah. So now, one of the things with a trust is people, we've talked about this in when we've talked about trust before, but when you have a trust, you have that entity set up, and then you have beneficiaries of that trust, which in this case would be your beneficiaries of your estate. You would then have trustees. So who should you have as the trustees, Tim?
Yeah, well, number one is people that you know, that you love, that you trust. Okay, similar to your decision around who should be your attorneys if you suffer an incapacity issue. Who do you trust to make decisions for you when you're either unwell or you're no longer with us? So we always look at the family dynamic. We would always prefer for the family to be in control of their own destinies. But what you need to be really careful of is, from the asset protection point of view, you can't create a trust where your son or daughter is the sole beneficiary or the primary beneficiary of the trust you've left behind. They're also the sole trustee, and they're making all the decisions. A family law court or a bankruptcy trustee will look at that and say, actually, that's not a legitimate trust. That's just an asset protection trick, and I'm going to ask a court to look through that for me. So individual trustees, as a rule, is a no-go unless that individual trustee is not a beneficiary of the trust. So a trusted advisor, the family accountant, the family lawyer, those types of professionals, they're good options because they're not conflicted. They're not beneficiaries of the trust. They can never be beneficiaries of the trust, but they can exercise the trustee responsibility with what we call objectivity, which is to say there's no conflict of interest because I'm not getting anything out of this. I'm a paid advisor, and I'm acting in the best interests of people who I knew very well, and this is their legacy. So joint is always best. We always prefer to hardwire backup beneficiaries, or at least a list of people that the testator, the person making the will, is comfortable with. So kind of like a choice of guardian, you list out people who you know and that you trust. And ultimately, you've got to see who's around at the time and who's willing to take on the job. But what we'll often implement, Ben, is multiples of children. So if you've got 3 children, we'll pick dynamics within them, the people who get along pretty well, and they will make joint decisions as trustees for the benefit of one another. And that actually brings me to a good point, Ben, is that you always have to be careful with these plans that you don't unnecessarily tie your children together financially for 80 years or up to 80 years unless that's really what you want to do. So if you've got siblings who are in a rural partnership, either with you or together, then it's a tried and tested dynamic, right? But if you've got kids who don't always get along, then it may not be a good idea. The test we use is we say often to the actual children when we're doing the more comprehensive exercise is, do you two want to buy an investment together? Yes or no? And often they'll say, yeah, we get along like a house on fire. We've got assets together. We own cattle together. No dramas. That's a good answer, a good test. If they say, we live apart, we love each other, love to catch up at Christmas, but don't really want to have jointly held investments together, then that says to us that they shouldn't be involved in the same trust. Very simple solution. You split the trust. You have one each. Sometimes you have joint assets. Sometimes you have a document that says if one wants to sell, the other can buy the other out. Otherwise, we sell it on the market. Not necessarily brain surgery.
Because that would be a bit of a rule of thumb, would it, Tim? And again, correct me if I'm wrong, that if you've got multiple children, like you said, you didn't want them to be tied together because eventually it's going to have to be pulled apart. You know, whether it be 5 years, 10 years, 80 years from now, it's going to have to be separated. So as a rule of thumb, you would generally, and this is not advice, but you would generally have 3 children. You would generally, when you die, 3 trusts would get set up, and then each child would have their own testamentary trust going forward.
Exactly. And that's a cleaner structure because you still have maximum flexibility. You've still got the ability for one trust to buy the other out, i.e. one kid to buy the other out, but you're not tying them together. Now, we've done lots of stuff after trusts have been created, Ben. You're not stuck with that trust for 80 years. You can split it, you can clone it, you can do all sorts of highly technical stuff. But again, like any job, you prefer to begin with the end in mind, measure twice, cut once. So our ethos is always to do it well, do it right the first time. And if things change, there are options, but they're always more complicated and more expensive if you need to change.
Yeah, appreciate that. And you've just touched on some of the negatives because I think we need to talk about those. So number one is tying your children together can be a bit of a problem. So that needs to be addressed. But what are the other risks, Tim?
Yeah, so like anything, there are pros and cons. I talk up these structures because I deal in this on a daily basis, and I think they are really great. I'm a living example. When my mum passed, we created one for my family dynamic. So I live them and breathe them. The complexity, definitely, going from a will that's 4 pages to 40 pages is something pretty daunting for some people. You know, another of our mantras is the KISS concept, keep it simple, stupid. If there's an ability to simplify something, we would prefer to do that. If I can achieve what we want to achieve using a 4-page will, I'd much rather do that. I don't push testamentary trusts to people who just don't need them. So the complexity is different. You have to then have a 40-page will. You have to make tough decisions like how much are you going to put in each trust? What assets are you going to put in each trust? Who are going to be the trustees? Who are going to be the potential beneficiaries? You've got to make a call on whether you want to contemplate step partners, step children, all that fun stuff is part of the decision-making tree. So the complexity is definitely a downside to that. There is a higher cost. So if you want to create an estate plan including a testamentary trust, it costs more for your advisor to do that as opposed to your 4-page will. We've talked about tying your adult children together, so we won't bang on about that one. But I definitely need to mention, Ben, that the introduction of a testamentary trust in your will not defeat claims against your estate.
Yeah, that's a really important point, a very important, especially in the rural space. A succession plan shouldn't be your will.
Yeah, super important, and that is a great mantra as well. Your succession plan is not your will because there is legislation and law in Australia that says disappointed beneficiaries can make claims on estates.
And the estate pays all the costs too, don't they?
Well, yes. As a general rule, if there's a legitimate claim, then the claimant is never out of pocket. The estate pays for everybody to fight. So fighting means you've already failed because your family dynamic is already upset. Hopefully not forever, but, you know, it's going to be an awkward few years coming up. But if you have a will that creates a testamentary trust upon your death and someone makes a claim on your estate by saying, I didn't get enough out of this, then it's still all up for grabs. Okay, it is harder for a court to say, well, actually, even though your wish was to create this trust, we're going to set that aside. A judge will always be very reluctant to do that. That's a last resort. But don't be thinking it's the silver bullet for asset protection. Okay, there are other tools in the toolbox we can use that are better guarantees, if you like, to prevent those claims. But it doesn't defeat the claims. Okay, that's something I want to be really, really, really clear about. It helps. It creates a bulletproof jacket concept. But like any bulletproof jacket, you can still cop a bullet in the arm or the leg. You live to fight another day, but it's still going to hurt a lot. So that's the analogy we use for that type of thing.
Perfect.
Probably lastly, I just want to mention, Ben, I call it the Gina Rinehart effect. And I'm sorry to mention Gina Rinehart because she might not like me saying this, but if you rule from the grave and you create one of these trusts and you make it really difficult for your children or your adult children to ever grow into comfort and decision-making with that wealth, you've just got to be careful with that. We all know about the high-profile court cases between the Rinehart family. It's a very good example of what not to do, because my reading of all that is that it has completely stuffed their family dynamic, that they fight over money. And for us lay people, we look at that and think, why on earth are you fighting over money? There's more than enough to go around. It seems like it's more about control than anything else. So just be really careful. Family harmony and maintaining family relationships is always the top priority when we look at estate planning.
And that's the big mistake I see a lot of farming families make, Tim, is they go, oh, okay, if when we die, there's 20 or there's 5 million or there's $50 million worth of farming assets here. They're going to get more than enough. They won't argue, but it's not the amount. Quite often it's the principles of things. I feel like I'm not getting enough. I'm not feel like I've been considered, etc. So I think it's really important. And, I just want to touch on this one thing before I ask you one more question here. But I remember reading something a few years ago out of America, and they said something like 95% of all estate challenges could be avoided if the family sat down together before mum or dad passed away and talked about what was in the will and what they want. So they have those discussions. So my one piece of advice I give everyone is, if you've got an estate plan, sit down with your children and run through it. Have those discussions. To the dads out there, man up and have those discussions. And sometimes they're tough about who's getting what, because in most estate plans these days, especially in farming, it doesn't have to be equal to be fair, and have those discussions before people pass away. So, Tim, TDTs or testamentary trusts, they're in your will. Are they like a McDonald's hamburger, a Big Mac? Everywhere you go, they're the same. Is every TDT or every testamentary trust, if you go to any lawyer, the same, or are there variations?
No, they're all very different, and each lawyer will probably have their own precedent. I guess we don't reinvent the wheel every time we come across it, but what you want to make sure that you're doing is going to a lawyer who specializes in this. And I mean, no disrespect to anyone who has broad skills across lots of different practice areas, but unless they're an estate planning specialist, they probably just don't do enough of these to really understand what they're getting their clients into. So if you've got a trusted solicitor, trusted lawyer who you go to for advice, just make sure that they're comfortable in this sandpit. And if they're not, just get them to plug in someone who is a specialist rather than cut them out. We work with lots of other lawyers who know the client, have the dynamic, and we just shadow them from a technical perspective to implement the documents. It's a much better avenue than someone having a crack at a TDT and getting it wrong, because it's like I said, yes, you can theoretically change it once someone has died. It's much harder, more complicated, more expensive, so get it right the first time.
It's interesting, Tim, just to give a little example. Again, I love to give these, but I had a family that was non-farming. They had multiple entities in business. And I remember they had a family friend who'd been a family friend for 35 years. He was a senior partner in a law firm in Brisbane, a very big firm, but he was a commercial lawyer and had nothing to do with estate planning. And I remember they had their estate plan done by him. They said, he's a family friend. He lived across the road from us. Our kids grew up together. We trust him implicitly, but he was a commercial lawyer and never did estate planning. And I remember we said, you've got to go through and review these wills. They're a bit old. And I remember sitting in the room and the lawyer going through them and then looking at it and going, oh dear, I found a mistake. And it was the wrong assets upon death were going to the wrong trusts, and it was complicated, but essentially he went through it and went, holy dooly, this is all wrong. And we worked out later on it would have cost a couple of $1 million in tax just because of this little mistake. Now, luckily we picked it up and mum and dad passed away the next year. It was lucky we caught it. It was because he was a great guy. He really knew the law in his commercial space, but he didn't know estate planning and he wasn't doing it all the time. And we caught that. And I think that's a lesson for everyone is if you're going to have your heart operated on, go to a cardiologist, don't go to your GP. And for most farming families, there's complexities that need to be really worked through. So that's really important if we do that. So Tim, we're coming up to the end of this now. So what's your piece of advice you want to give anyone if they're considering a testamentary trust or reviewing their estate planning? What's the one piece of advice you'd give them?
Ask questions. That's the best piece of advice we can give. Educate yourself and ask the right questions from the right people. But please, please, please don't put this off until life gets in the way and you are forced to do something in a rush. Okay, good estate planning lawyers have lots of tools in the toolbox. We can do some really cool stuff in this space, but we need time to do it. The average length of a well thought out, well structured and planned out estate plan is 1 to 2 years. Okay, that's a really, really long time. But often we will have a session together and then we'll all go away and think about it for a month, 2 months, let people percolate over particular options and ideas, and some really cool stuff can happen. If you wait until something happens and you get a diagnosis or whatever, and we have 30 days, 60 days, 90 days, we're quite limited in what we can achieve and you won't get the best possible outcome. So please be proactive, stop putting it off and do something about it.
Yeah, it's great advice, Tim. And the one piece of advice I'd give everyone out here is going back to that point I made before about dads. Quite often people avoid estate planning for 2 reasons. One is it becomes a little icky for them because they go the equal to be fair. Oh, how are we going to deal with this? But there's an awesome way to ruin your legacy, because that's what a lot of men are worried about, is dying and leaving a shit fight and your family all falls apart and that asset gets lost anyhow. So the rough rule of thumb is harden up and do it. Number 2 is I see so many people, Tim, and I've referred people over to you where this has happened, where they've gone back and had 1, 2 or 3 goes with the lawyer and they get to a certain point, it gets hard, they put it in the bottom drawer and go, oh, that's all too hard, I just can't work that out. And then they don't do anything, and then 2 years later come back and they have 3, 4, 5 goes. And I think if you're going to do this and do it well, is you need to find the right lawyer. You need to follow them up if they don't follow you up, or you need to empower that lawyer to say, look, we need to get this done in a timely manner and to follow us up. Follow up, put the pressure on us and make sure we actually get that finalised, because having a will half done is like having no will at all.
Exactly. It won't protect you unless it's signed on the dotted line. And we establish those ground rules with all clients who come on board to us. We flat out tell them that we are super dogged and we will not leave you alone until this project is completed. And, people get busy. We totally understand. Different priorities come up. But we've had situations where we've said to people, I'm going to drive to your property and sit at your dining room table and we are going to finish this together. And you just have to sometimes do what needs to be done to get the project over the line.
Yeah, no, that's a very important point. Just get it done, sort it on, and then move on. So, Tim, where can people find more about you online, mate?
We're on socials. So we trade as Robert Harris Rivett Lawyers, also RHR Lawyers, because the first one's a bit of a mouthful. Probably go to our website, www.rhrlaw.com.au. Excellent.
Tim, if you could go back in a time machine, mate, let's say 15 years till you're in your 20s and you manage to catch up with young Tim, what's one piece of advice you'd give him?
I'm going to cheat and give him 2. Number 1 is enjoy your hair, mate, because you're not going to have it for much longer. But no, seriously, enjoy the ride because it all works out okay. I'd love to say that to my 20-year-old self.
Yeah, don't be so wound up about things. I saw a quote this morning, Tim, that's very serendipitous, but I saw a quote. It was something along the lines of, everything's going to be all okay, mate. And if it's not okay, it's just because it's not okay yet.
I like that. It's very true. You should get it printed on a shirt or something.
Yeah. Can you see that? The Financial Bloke T-shirt. Maybe I'll do the Forrest Gump one. Shit happens.
Yeah, shit happens. Much better.
Awesome. Well, look, Tim, thank you very much for that. Hopefully everyone's really enjoyed that introductory technical lesson. And if you enjoy these technical sessions, drop me an email, drop Tim an email, let us know. It's always nice to get that. And if there's a topic out there you want to hear some more information about in either the asset protection, the estate planning, the family law, etc., let us know. And we might run a couple more of these as we go on. So, Tim, thanks very much for your time, and we'll see you with the next one.
Sounds great. Have a great day, everyone.
Well, thanks, Tim. I really love having Tim come on the podcast. He technically is really, really good at what he does. He's very articulate, which is great, and relatable in everyday terms. And also, he gives up his time to come on and educate everyone. So I just want to say thank you to Tim. We really appreciate it here at the podcast. Now, a couple of points I just want to leave with you guys before you go, because I know a lot of you are either in the tractor, in the truck, mustering on the horse. I had someone the other day, or in the car. First thing is, you need your estate planning in place. Don't leave it until the last minute, and don't think that if you die, they'll deal with the problems. Get it sorted out now. Number 2, make sure you get advice from the right person. Tim mentioned that. Get an estate planning specialist, someone that knows that stuff, and get to know what things are. Understand the vernacular means you can have a conversation with a lawyer. And finally, if you've got an intergenerational business, like most farmers and agribusiness owners are, and you want to protect those assets in the future, you've really got to invest an appropriate amount of time in this, because if it takes not only your time, but also your money to get this right, I can guarantee tell you that, when you die, because it's not an if, it's a when you die, it'll cost far more in lost family relationships or busted up family relationships, legal fees and tax than it'll ever cost you to get this done now and fixed. So get onto it. You know what a testamentary trust is. Ask your lawyer if that makes sense for you, and make sure you drive that project to the end. I want to reinforce the point that having a will half done or half-assed is not a proper estate plan. You need to get that worked out, and the risks are getting higher and higher every year, especially with, as Tim said, my son-in-law is an idiot or my daughter-in-law is an idiot. Divorce is getting higher and higher over these days, and we want to protect what intergenerationally multiple generations have been building. So that's it for me today. Hopefully that's a couple of points for you and you've enjoyed this technical update. If you find the podcast valuable and you think other people would enjoy the podcast or get something for it, we'd love it if you could share it with people. So send them an email, drop them a text, share it on the socials. And above all, the way we get out there and share the wealth and wisdom with more and more families is we actually have people that give us 5-star ratings on Apple Podcasts and also on Spotify, the 2 major platforms. So if you could do that, we'd be eternally grateful. So that's it for today. I'll see you in 2 weeks' time.